I thank the gentleman from Nebraska, and also the chairman of the Housing and Insurance Subcommittee, Mr. Flood, is now recognized for 5 minutes.
Thank you, Chairman. My interest in stablecoins goes back to the work I did in the Nebraska unicameral legislature on this very issue. After my bill entitled the Nebraska Financial Innovation Act passed, Nebraska became the second state to have a regulatory structure for a new kind of state-chartered bank called a digital asset depository institution. A Nebraska digital asset depository institution can issue stablecoins, which puts my state in a unique position as it relates to the broader debate about a state pathway within this bill. Due to the laws in our state, I'm interested in the state pathway specifically as it relates to state-chartered bank issuers. My hope is that any federal stablecoin legislation will work hand in glove with our Nebraska Department of Banking and Finance and the work they are already taking on these very issues, and I appreciate the continued dialogue we've had with Chairman Hill and his team on ensuring that we strike just the right balance. Mr. Gwynn, can you please walk through your understanding of how the Stable Act would regulate a state-chartered bank subsidiary that issues a stablecoin pursuant to the bill's state pathway?
So as I understand it, there's sort of two possible regulatory frameworks. One is 4A, which sets federal standards, and then 4B that would allow a state to have an alternative regulatory regime that would satisfy or exceed those standards. So it's a little bit more restrictive than the dual banking system, where states have a little bit more freedom because the federal standards simply, it's not that they don't apply, it's that they cover a much narrower field of applicability, whereas here the standards are pretty comprehensive.
Good answer, because you answered my second question about how it compares to the dual banking system, so thank you. I'd like to emphasize a few things about the state pathway before moving on to my next question. One is that state regulators must get a certification approved by the Treasury, as you've said, showing that their state regime is in line with the bill's federal requirements or exceeding the federal requirements. In addition, there is an exigent circumstances provision in the bill that would allow a federal regulator to step in over a state regulator and enforce directly on state issuers in certain circumstances. And quite honestly, this has concerned me, just what is an exigent circumstance, but in other words, even the state pathway has a very extensive federal involvement. With that caveat, I'd like to highlight a line in Mr. Cascarilla's testimony, which said the following as it related to cross-border regulation of state-chartered stablecoin issuers, and I quote, "Primary oversight should remain with state-chartered issuers, home state regulator, avoiding redundant regulatory burdens," end quote. Mr. Cascarilla, if a state pathway for insurance doesn't include some form of regulatory primacy for the rules of their home state regulator, would state issuers juggling several state regulatory laws be at a disadvantage relative to issuers that receive a federal charter?
Yes, they would, and I think that is the exact point, which is today, as a state issuer, you have to juggle a number of different state approvals and exams, and that is a conflicting process that takes up a lot of resources and could certainly snowball in a situation like this.
And I appreciate that answer. And let me just say this, does anybody in this room not think that the New York DFS could handle this? I mean, we have to respect the rights of states to have their own regulatory regime. Mr. Gwynn, can you comment on the same question? Juggling all these different regulators, does it put the state chartered issuers at a disadvantage?
So look, we get this question all the time from state issuers as a law firm. There's always a choice, but having a choice between a state and a federal regulatory authority is a good choice to have. And so it may well be that a particular institution decides, I have more freedom to innovate if I'm regulated by a state, even if I have to go through the headache of looking at all these different state laws. Whereas if I go with a national regulatory, then it will be preempted.
Totally agree. And let's remember, what makes America the best financial market in the world, what makes us so successful is that we have diversity in our banking. We have the GSIBs, we have the regional banks, we have the community banks, we have the federal chartered, we have the state chartered, and we have innovation. When you control all of that, you get Europe with a couple of banks and a couple of board of directors that are making the decisions for every consumer on the continent. And so let's celebrate what makes America strong by encouraging diversity, relying on states to manage and regulate state issuers of stablecoins with appropriate safeguards. I want to compliment Chairman Hill, Brian Stile, Mr. Davidson, Allison and all of the work that the staff has done. We are in a good place because of the hard work of this committee, and I'm excited to see this bill pass. With that, I yield back.